All right, everyone. We start? Good. Welcome aboard. Hopefully we're going to have a nice day so far. Today will be a jam-packed class, so hang on. So you had a question, sir. Why are you asking this for everyone else?
I was going to ask you.
Okay. Okay. Yes. You can come to see me 15 minutes after class. That's okay. Thank you. All right. Any other questions? All right. Today's class, I really see as somewhat of the crowning achievement, or the capstone case, if you will, of our entire unit, because it unites many themes we've talked about. It unites equal protection. It unites due process. It unites federalism. It unites the separation of powers and the role of the courts. And more broadly, democratic theory and how our courts fit in with our tripartite system of government. And to begin, I want to tell you a little story. So in October, just this past, 6 months ago, Jim Obergefell, the lead plaintiff, came to Houston. Did anyone else see him? Los Angeles so good at these things. So he actually came to Houston. He was at Discovery Green, really far away, 3 blocks away, right? And he was giving, a lecture on his experience on the Supreme Court, his history, and it's a really touching story. He told the story of how he had been living with his then partner, a guy named John Arthur. He told this story of how they met at a bar or something, right? And Obergefell was like, "Oh, he's gay." He's like, "No, he's not." And they had this entire debate, and they found he was, and they started dating, and then they had this really long-lasting and loving and caring relationship for many years. And then Arthur came down with ALS, Lou Gehrig's syndrome, as you may know it, and this is a debilitating, lethal symptom. There's no cure for it. So his condition became so severe that he wasn't going to live long enough to perhaps see Ohio, their home state, legalize same-sex marriage. So they came up with a solution. They would get a medical transport plane, which is basically like a private jet with a doctor standing by and all the equipment. They were going to fly from Ohio to Baltimore, Maryland, where the legislature had legalized gay marriage. Touchdown long enough for a person licensed in Maryland to perform the wedding, say "I do," right? Then zoom and fly back to Ohio. So that was actually the predicate. And in fact, Arthur died. And what Obergefell's lawsuit was about was not actually a right to get married. He had been married. It was a right to have Ohio recognize his out-of-state marriage to amend the death certificate. Because the death certificate of Arthur said he died single. And there are various wills and trust issues that are not really important here, but Obergefell wanted the death certificate to be updating. No, he wasn't single when he died. He was a married man. So I was there. I was watching him. I didn't really have a plan. I wanted to see what the guy wants to say. And as I always do, I always have a constitution in my pocket. I always keep one handy. So I've actually have a collection. You can come to my office and see it. But a collection of autographed constitutions. You come to my office later. I'll show it to you. My prized possession is a constitution signed by both Scalia and Thomas, which has now been even more dear to me that Justice Scalia is no longer with us. I once had asked Justice Scalia to sign my Second Amendment after Heller. He said no. I've rejected many times, but I was persistent. So I went to Obergefell and I was like, I really enjoyed your talk. Would you mind signing my constitution? He's like, "Oh yeah, sure." So I don't even know why, but I'll show you a picture. I have it here, but I blow it up. I don't even know why, but I said, you know what? I asked Scalia to sign the Second Amendment. Let me ask Obergefell to sign the 14th Amendment. So you can see it here, and I have it there. And he wrote, Jim Obergefell, love one. The penmanship's not the best. But it's okay. He was scribbling quickly. And I was looking, I was like, man, with apologies to Taylor Swift, the 14th Amendment had a blank space. And he wrote his name. But it's not just on a Taylor Swift level. It also, I think, works on a philosophical level, because indeed, the 14th Amendment is different before and after Jim Obergefell. And I don't mean to single out Obergefell, he's a great guy, but his case, along with many other people, indeed changed the 14th Amendment. And I was sitting there, I was like, wow. Because I was thinking, how am I going to teach this case? This is probably the hardest case I've teach all, the hardest case. I spent a lot of time thinking about this. Like, how am I going to teach this? I'm like, wait a minute. Right there. You have due process, you have equal protection, and you have the love one clause, right? And it's as if, and I'll put this for later if you want to take a look at it. In many respects, this is a decision that amended the Constitution. And I don't say that at this moment, at least, with a positive or negative connotation, but the court acknowledged that the 14th Amendment meant something different before than it does now. And the declaration of that was in the Obergefell decision. And I like to begin the event this way to frame. Oh, and here's a picture of Obergefell signing my Constitution. I'll eventually scroll, but that was him. Really nice guy, very interesting story. I'm sure it's recorded somewhere on Discovery Green's website. You can watch it. But I want to start, there he is, yeah, sign with my Constitution, right? You can see him scribbling it in. So, lest you have any doubts, that's my authenticity. And I tried to get another picture, but it got blurry. That was about to give me thumbs up. So, and here's him giving a talk. Okay, I'll leave it. I'll leave it with this one because it's a better suited image. So, how do we understand then the Obergefell decision, right? How do we approach this? So my blueprint for today, and other than Obamacare, there's the only case that gets an entire day. I don't think 2 hours is even remotely close to being enough. My blueprint for today is to try and discuss this in a few levels. In terms of doctrine, right? We spent all this time talking about equal protection, due process, fundamental rights, scrutiny, whatever else, to talk about the judicial role. Right? Where do the courts fit in? And I want to talk about the broader societal issues. So before I begin, I want to show you something. Where is it? I think I have it in the last class. Here it is. So this chart, everyone know Nate Silver in 538? He's like this math guru who predicts these things for the future. He's really a smart guy. He called the 2012 election down to the last vote. Last electoral vote, that is. So in 2012 or 13, when I first started teaching this topic, he put this chart on his blog. And what he tried to do is project, what is support for gay marriage going to look like in 4 years and in 8 years? So he had numbers from 2008, the numbers from 2012, so he tried to project it forward. And the purpose of this exercise was to illustrate at what point will a state hit the 50% threshold? Because Nate Silver was thinking, man, when a state hits 50%, it can go on the ballot, and then, or it can go through the legislative process and be enacted. So, again, this is in 2013. So by 2012, roughly half the states in the union, starting with Maine going up, okay? I'm sorry, Nebraska going up, we're right around the 50% mark, roughly half the states. If we scroll down, I think Texas was not quite to the bottom, but it was here at 45.8%. So it wasn't quite a 50-50 issue. It was like 45%. And all the way at the bottom was poor Mississippi, right? Mississippi's at the bottom. Then Silver projected ahead another 4 years. He said, okay, what about in 2016? Well, that 50% mark moves up a bit, right? And then what about in 2020? Well, that 50% mark moves significantly up. And Silver predicted that by the year 2020, let's see, 1, 2, 3, only about 6 or 7 states, Texas indeed crossed the threshold. There will only be about 6 or 7 states that same-sex marriage would still be below 50%. And Silver used this as an illustration of how social progress can happen in the span of literally 12 years, from 2008 to 2020, how this issue may be resolved, not quite completely, but awfully close to completely. Ironically, and perhaps Silver didn't predict everything, Silver didn't even anticipate that in 2012 or 13, the Supreme Court would just end this in a couple of years, right? We ended it right here. I mean, right? It just cut off. 2013. I'm sorry, 2016. Like, right, I point through a place right here. It just got cut off, and there were a significant number of states that perhaps would have switched over, but time didn't allow for it. So that's the final theme that I want to discuss. In the absence of judicial intervention, our society does not exist in a vacuum. And even by these fairly conservative estimates from 2013, which I don't think were way too conservative, had the court not did what it did, given another 5 years or so, virtually every state would have probably legalized same-sex marriage. Not everyone, pretty much everyone. And I think then the social pressures would have built to perhaps change the rest of them. But that didn't happen. And this is probably the thrust of the Chief Justice's dissent as well. So we'll talk about doctrine today. We'll talk about the role of the courts. And we'll also talk about social change outside the courts. That's my goal for today. I have about 90 minutes left to do it. So 80 minutes. So any questions before we get started? Things on your mind? No? Yeah.
You go to the court to watch the video?
For this case? Oh no. The line for this case was, I think, the longest ever. I think people waited 5 or 6 days on the street for this case. I mean, literally, you're living in the tent, right? You're camping out on the tent in the streets of DC. So no, I was not there for this case. In fact, a lot of lawyers, because if you're a member of the bar, you get a special line. It's called the bar line. A lot of lawyers paid line waiters to go into the bar line for them. And as a result of this, the Supreme Court prohibited line waiters on the bar line. Yeah, this case, I think, had the longest. This made Obamacare look like nothing. This case had a long line. So I did not go for the arguments in this case. Thank you for the question, though. So I always like to, again, of course, Kennedy has basically defined our liberty jurisprudence the last 30 years. He wrote Casey, right? Casey began, liberty finds a refuge in jurisprudence of doubt. He wrote Romer. Romer began, the Constitution neither knows nor tolerates classes among citizens. He wrote Lawrence. Liberty protects the person from unwarranted government intrusion into a dwelling or other private places. He wrote Windsor. The introduction for Windsor sucked. I don't know what, he slipped it. He said, 2 women then residents in New York were married in Ontario. Okay, yippee, right? But then we get to Obergefell. And this is, I think this might be his most purplest prose. He wrote, the Constitution promises liberty to all within its reach. You don't have to write this down. This is in the book, right? You don't have to, just listen. If I'm reading from an opinion, you don't need to copy verbatim. The Constitution promises liberty to all within its reach. A liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity. The petitioners in these cases seek to find that liberty, like Nemo, right? By marrying someone of the same sex and having their marriages deemed lawful on the same terms and conditions as marriages between persons of other sex. Of the opposite sex, sorry. So this case, right? This case from a philosophical level, and I always try and get inside Justice Kennedy's mind, and I always give him the benefit of the doubt. I sincerely try. I don't always succeed, but I try. For him, he views marriage as a way to seek freedom, as a way to seek liberty, as a way to project dignity and humanity for your person. And if the state declines to give people that sort of dignity or liberty, they are prohibiting that person from seeking that freedom, right? The state granting of this license, it's a little stupid piece of paper. If you get a marriage license, it's 1 page, right? It's not, we're not talking about a lot of things here, right? But that is what gives a person their dignity. And withholding that piece of paper denies a person that dignity. And I don't want to dwell on this point, but for any of you who were at the lunchtime session about free speech, if you notice, a lot of the speech codes on campuses prevent you from degrading, demeaning, or taking away someone's, dignity. These are one and the same. What Justice Kennedy has effectively done is make it a constitutional violation for the state to make someone feel bad. That if someone makes you feel like you're less of a person and it hurts your feelings and demeans your dignity and takes away your humanity, that becomes a constitutional violation, which a state cannot do. Okay. So the facts of the case, and I'm probably going to lecture more than I usually do because this case is so long, but I promise I'll start calling out people. Don't worry. In other words, all these kids are skipping class to go to moot court. They'll be off, but you guys will have to pick up the slack. So the case actually was not just one case. So after United States versus Windsor was decided, a strategy was announced by various gay rights groups. The strategy was called "Sue the Bastards." Okay. Before Windsor, the gay rights movement had a very rigorous and disciplined strategy. They said, we cannot bring a same-sex marriage case to the Supreme Court because we'll lose. And maintaining uncertainty is better than losing. So indeed, even the Prop 8 case, the Hollingsworth versus Perry, that was brought by two lawyers who are not sanctioned by these various Lambda Legal, the ACLU, the Human Rights Campaign. These groups are not like the Hollingsworth case. They thought it was too soon, and the Supreme Court dumped the case on standing. Okay. But after Windsor was decided, and Justice Kennedy basically signaled that denying gays and lesbians a tax refund demeans their dignity, then the case for marriage becomes a heck of a lot stronger. So a memo went out, and there actually, that wasn't a formal memo, but a tweet went out at least that said, "Sue the bastards." And in 50 states, actually not 50 states, in 38 states, however many states hadn't legalized gay marriage yet, lawsuits were filed. And not just by the ACLU, or like even small groups said, we're going to sue. We have this guy, we're going to sue here, we're going to sue there. Okay, there were I wrote an entire article about this. There were like probably 40 or 50 lawsuits filed nationwide, challenging various marriage lawsuits. The cases proceeded in a somewhat unexpected manner. The first court to rule in all places was in Utah, a state whose admission to the union was contingent on allowing only one man and one woman to be married. And the judge in this case, I don't say this lightly, issued his ruling, I think, the day before Christmas at like 5 p.m. Okay? Usually, when a judge issues an opinion that changes the law, he stays or puts the opinion on hold. The effect of that is, okay, let's keep the status quo. You guys can appeal this, and then this way we don't have chaos in the meantime. The judge in Utah refused to stay the decision. As a result, within an hour, people started running to City Hall in Salt Lake City and getting married. And there were celebrations in the street. And I spoke with some of the attorneys involved. I mean, they were scrambling to file this emergency appeal. I think 12 days happened before the Supreme Court finally put those on hold. And in the meantime, I think it was 1,000 couples were married. Okay. The second this happened, I said, "Oh man, this is over." Right? I was like, "This is a done deal. This is the train, right? The train's chugging along. This is a done deal." But the Supreme Court put it on hold. A number of other district court judges also invalidated the marriage laws and didn't issue stays. And there's a race to the courthouse, and then the Supreme Court put it on hold. So eventually, the Supreme Court had put on hold every single judgment invalidating these marriage laws. Okay, even though thousands of people already had these licenses in this race to the courthouse. Then finally, in September of 2015, was it 15? No, it's 14. The Supreme Court denied review. They denied certiorari on a number of petitions from various circuits. They just denied certiorari because every court had held that the gay marriage law is unconstitutional. They denied cert. The effect of that denial of certiorari was that all the stays lifted, and in September there was a race to the courthouse because now the marriage laws in about 20-something states were unconstitutional. Without even writing a single word about the merits, the Supreme Court basically lifted the stays and let gay marriage proceed in all those states. Ask yourself, at that point, what was the point of even arguing this case? They had already signaled that the challengers were going to win. But then about a month later, there was a case involving the Sixth Circuit where I clerked, which is the states of Ohio, Kentucky, Michigan, and Tennessee. And a judge in that panel, Judge Jeffrey Sutton, who also wrote one of the Obamacare decisions we talked about earlier, issued a decision upholding the marriage laws in Ohio, Tennessee, Kentucky, and Michigan. And that finally created a circuit split. And that paved the way for the Supreme Court to actually hear the case that became known as Obergefell v. Hodges. Now, repeat, Obergefell. It's a mouthful. It's a tough one to say. There was actually another plaintiff. The name was Loves. And I was like, oh, well, it'll be Loves. That'll be an easy one for my students to remember. But no, it's Obergefell. Fine. Okay. So the case goes to the Supreme Court. And at this point, again, it was a foregone conclusion, right? No one thought that this case would come out any other way unless it was some sort of act of God that, the clouds parted at Anthony Kennedy, do not do this, right? Unless something crazy happened, this was going to go the way it happened. So it wasn't a surprise, but I want you all to walk through the analysis, okay? So where did I finish up last time? Okay, thank you, Whitney. Whitney, where did marriage come from? Whoa, well, you weren't expecting that one, right? Whoa, what, I mean, after reading these opinions, you read through a lot, different takes. Where did marriage come from? Marriage was invented in 1776?
Well, no, I was saying
No, I'm asking, where did marriage come from? I'm not talking about the United States of America. Where did marriage come from? Okay, be more specific. Oh, there were marriage long before the Pope. Long before Jesus, there was marriage. Paul. Nick, what do you think? Where did marriage come from?
Well, Robert said something about the institution that was formed for basic society for millennia. He said something about caloric nutrition and hot Chinese.
Okay, you're reading from opinion, which I appreciate, but where did? No, you're on the right track. We're on the train, right? Where did it come from?
It's probably to give meaning. The other thing they talked about was stability, right? So that allows two people to combine to create cooler resources.
Okay, good. Nick, let me ask you. You're answering my two questions later, so you're actually ahead of the train. But I'll get there in a second. Nick, let me ask you this question: was there ever any sort of meeting or convention where people came together and said, "All right, let's make marriage," like the same way you have a statute says, "All right, let's impose this law on tort liability," right? Right. How do we know it's unlikely? What you just said, what evidence does Roberts bring forward to suggest there was no sort of international convention where everyone agreed that, okay.
Because everyone had been doing it.
Literally, they were doing it, right? That's actually quite astute. So, Will, if there was never any sort of international convention, right, where the Han Chinese and the Kalahari Bushmen and the Aztecs and these other, these groups all around the world, right? They had no communication. How did they all arrive at the same idea of marriage, that a man and a woman come together, the society, whatever, recognizes that and encourages that? How did this all go down? If these groups were totally independent, there was no communication back then. There's no like a Twitter hashtag marriage hashtag, right? I don't know. What was that? What about it? Well, you don't need to be married to have children. Reproductive organs are not bound by anything. You could have sex with whomever you want. How did all these groups independently come up with this idea of one man and one woman? Where did this come from? Why did this tradition evolve? So tell me more. What's the stability business? Okay, good. You want to take a stab at it, Sean? I think you guys are on the right track. Yeah. Why did this same tradition of encouraging one man and one woman evolve in these traditions and societies all over the world, all different, perspectives on life?
I think it's because I can relate it to I read in the case where the idea behind it is to encourage responsible procreation.
Encourage responsible procreation. What the heck is that?
So it's the idea that if you allow people to get married, that they have a better chance of staying together for their children.
What encourages them to stay together?
Just the notion of having that inherent bond, if you will?
Well, it's not just internally. What external pressures encourage people to stay together with this marital institution?
Well, I think at the time, especially back then, there was a lot of heat on people having children out of their lives.
Ah. So if I can restate what the backbenchers in the last row just described, and I don't mean that pejorative. I think your answers were quite good. It was about incentives, and incentives matter. And let me state the issue clearly. Generally speaking, single mothers will be, at least historically, maybe not today, but historically at least, Murphy Brown, whatever, but historically, single mothers had a harder time raising children than a single mother with a man. Okay, I don't think anyone dispute that as a matter of history. Today, I'm not making assertions about that, but historically, in the survival of the fittest, two people can better provide for a child than one. Okay, this is what Sean referred to as responsible procreation. The idea is, if two people are together and they raise that child together, the child will be in a better place than if there's one person. Right? This is a concept that's entirely alien and foreign. In fact, when I taught this class last semester, I did this backwards. I first asked, what's responsible procreation, and no one had a clue. But when I backfilled it from history with the Kalahari-Bushman, now it makes sense. So I improve myself every semester. So we don't think about this today, but these institutions evolved because societies around the world not communicating decided we need to encourage people to stay together for the children, right? We need to shame people who have kids out of wedlock, and we need to shame deadbeat dads. We need to make a social shaming of men who don't stay with the mother of their children, and we need to make a social shaming of people who have children out of wedlock. The flip side of this is we encourage marriage. It's not just a stick, it's a carrot, right? It's a carrot and stick. What do? We give certain benefits to married couples. Someone said religion. We allow them to take communion, right? We allow them to inherit property. Later on, we give them tax benefits. We give them coverture, which sounds like an awful thing, but it actually allowed women some sort of stake in property, which they didn't have before. The entire idea of what an institution is, right? What does this mean, institution? It was a way of life. It was a way of actually growing the species. And indeed, in many of the opinions cited, Meyer v. Nebraska, Pierce v. Society of Sisters, Oklahoma v. X. Rel. Skinner, all these cases, Griswold said marriage is a way of life. And I think I mentioned this before, but the reason why marriage was a way of life was because our society would die. If people didn't procreate in a responsible manner, we would actually lose population and die out as a species. This is why society is disparate as the Aztecs and the Kalahari-Bushmen, right? These are very different societies, all arrived at the same conclusion. Indeed, polygamy, if you actually think about it, is super responsible procreation, right? You're pooling more resources together. Talk about the sister-wives, right? You're actually pooling more resources together. What's better than 2 parents? 3 parents, right? Or 4 or 5, whatever it happens to be. It takes a village, yeah, exactly. So indeed, many societies decided that perhaps 3 or 4 wives is better, whatever happens to be. But this was developed as an institution, okay? So, and this is the point that the Chief Justice, I think, makes more than the others, that historically, the reason why marriage was viewed as an institution was not because of love, right? It wasn't because of happiness and dignity and whatever else, tax benefits. It was viewed as essential to the survival of the species, okay? So let's look at a couple of the potential detours from this history. So, Cash, what happened with Loving v. Virginia? Right, that was the case, I'm sure you guys remember, where the Commonwealth of Virginia passed a law that prohibited interracial marriage. It actually made it a crime to go across state lines and get married and come back. Cash, what was the problem there? Right? What was the issue in that case? Not just equal protection. I'll talk about due process, right? What was the problem in Loving? remember, there were two components of the opinion. There was the equal protection component, and there was a due process component. I want to talk about due process. We did equal protection last 2 weeks ago. On what grounds did the court invalidate the law in Loving? And if you don't remember, you can talk it out with me. With respect to due process. That's right. That's right. That's right. So I'm asking about how, in what respect did the court invalidate under due process? What was the liberty interest at stake there?
Because they were unequally treated.
Oh, no, you're doing equal protection. I'm talking about due process. I know I'm not yelling at you because, in fact, the court's opinion blurs the two very poorly. What was the answer my question? What was the liberty interest at stake there? What was the liberty interest at stake in Loving?
Because they had fundamental rights.
Okay, the fundamental right to marriage, right? And what was the state's reason for excluding interracial couples from that fundamental right? I think you're on the right track. You're close. And Alexa, you're on deck. Gosh, look at her already. Take one more stab, then I'll go to her. What was the state's interest in Loving to deprive interracial couples from this fundamental right? Alexa. Alexa, you want to take a stab at it? What was the state's interest that they asserted to promote this sort of law?
I thought that it said that the state like, didn't have an interest. They were just trying to like maintain status quo and like
Status quo of what? White supremacy. That's the answer we're looking for. Ding, ding, ding. $100 answer, right? The state's interest. You're so relieved, right? You're good. You're good. The state's interest, and they asserted this. They said our interest in the statute, right? It was right there in the statute, was white supremacy. Okay, white supremacy. That was their stated interest, and the court said that white supremacy is not a legitimate interest of the state. Right? Forget whether the right's fundamental or not. Right? This is not even like a rational basis. This is a totally illegitimate purpose of the state. Okay. Now, Morgan. And I think I mentioned this last time, but when did these rules about interracial marriage start popping up? Do you remember? Were these old rules or of a recent vintage? When do you think they started popping up? When did Virginia enact its interracial marriage law? Do you remember the year? Ballpark? Remember the year? 1924, right? A lot of other states are enacting them like in Reconstruction, 1880s, 1890s, early 20th century. Okay. So, Scotty?
I'll say before they were acting statutes, wouldn't you say it was de facto rather than de jure?
Oh, I love. Tell people what de facto de jure means. They may not know.
De jure means by law. De facto means just as a matter of the way things are.
So actually, no. So the interesting answer is in most societies. Sorry, I didn't mean it like that. I didn't mean it like that. It was actually a really good question. But in most societies, there wasn't a ban on interracial marriages. This was actually a distinctly American experiment, right? It didn't actually. It was actually interclass marriage, that you would not have a rich person marrying a poor person, but there are no actual laws of interracial marriage. For the simple reason is that most places races didn't mix until colonialization, so it's a totally different story. But it was more of a rich poor than white black issue. But you're on the right track. But I forgot I let Morgan off the hook. So let me ask this question again. So assuming that these laws were fairly recent, right? Would you say that these social laws were a deviation from this 2,000-year-old tradition of marriage? Or basically any man or woman can get married? Okay, let me ask you a follow-up question. In any respect, could Mildred, what was the guy's name? And John, the Lovings, right? In any respect, could they, was their procreation ability in any respect different from a couple that was of the same race?
race? No.
Can a black and white person recreate in just the same manner as two white people? Okay, good. Thank you. I think that's the right answer. Okay. What the court didn't quite say, but I think is underlying the opinion is a black and white person are just as able to copulate and have a child as two white people or two Asian people or two whatever people, right? Everyone agree, right? It's not like what was it when you have a donkey and a mule and then they make what is it? It's a like I don't know, animals, right? Whatever. These are people of the human race, and they're able to reproduce just the same. So to the extent that marriage is about promoting the human race, in no respect does an interracial marriage get in that way. So, and this is actually the Chief Justice's dissent, and a little bit of Thomas as well. A common analogy saying, well, a law on interracial marriage is no different than a law against same-sex marriage. And I mean, that argument has merit, but I think the obvious rejoinder is the purpose of the Virginia law, as we just said, was white supremacy. It had nothing to do with the actual reproduction of the species. So then the question becomes, what then is the purpose of laws enacted by the states to limit marriage to a man and a woman? Okay, what is their purpose? So you're up next, Christine. Texas voted for one. I think it was in 2001 or 2002, passed by like 60 or 70% to amend the Texas Constitution to prohibit same-sex marriage. What was the purpose, Christine? And you can have maybe multiple answers. I'm not looking for one answer in particular. But Christine, what do you think was some of the purposes for that law? Well, I mean, yeah, that's the effect of the law. But why was the motivation, for enacting that law? Okay, on the right track. Alarm, let me move on to you. In what respect could legalizing same-sex marriage weaken this institution of traditional marriage? And how does it actually work? There's another point that I think students don't actually get, but I'm going to try and walk through it. In what respect does legalizing same-sex marriage harm opposite-sex marriages, if at all? But give the argument that you think as it may.
Well, it goes against the question of trying to responsible procreation.
How? But going against tradition, that doesn't fully answer my question. How does it diminish it? You're looking for a lifeline, right? No. How? Well, I get how that impacts the children, and we can get to that point in a few minutes. My bigger question is, how would legalizing same-sex marriage affect other potential opposite-sex marriages? So, students don't know this one. It's interesting. I'm not faulting you at all, but it's not taught. This issue is never taught, which a lot of people don't understand this case as well as they ought to. You want to take a stab, Sydney? What do you mean? You're on the right track. Elaborate, please. You're on the right track. Interesting. You want to elaborate on that, Randall? I think we're moving in the right direction.
So it can be seen as a disincentive for the purposes of procreation, in the sense that you're now allowing people for other purposes outside of what was traditionally presumed to be
okay.
to get married. And so you're in a way changing the ends that you're seeking and changing the values that are being held within.
Interesting. I'm going to go. Charlie, your hand was up a minute ago.
I was going to say it kind of changes.
Oh, Charles. I'm sorry. I called you Charlie again. I don't know why.
I guess I was pretty much going to say what he said in just a less nice way, pretty way. But I was going to say that it just kind of changes it from the entire purpose from being procreation to being about love.
Oh, from procreation of love. Dan, what do you think?
I think the court dances around it.
I'm not getting to the court. I don't care about the court yet. If you notice, I haven't mentioned word of Kenny's opinion in a while. We'll get there, but it's not. This is much more profound. And so you actually get the issue. Kenny just does a little dance, right? I want you to actually understand the issue.
Well, going back to what family means and so forth, at the formation of societies where families started forming, one of the purposes that the family unit also served was to somewhat regulate sexual behavior. Father shall not sleep with the daughter, cousins, and everything.
Good idea, generally speaking, yeah.
Right. But here, the issue is kind of avoided with flowery language of love and everything like that. I think there's a legitimate fear in a way that the institution of marriage will somehow be attacked by completely breaking the bounds of this perceived sexual behavior as well.
Okay, so I think we had a lot of different threads here, and I'm going to try and synthesize them, if I may. So the argument, I think, generally goes like this. People are encouraged to get married. People are encouraged to get married because it's viewed as a special institution with certain benefits. Marriage has historically been tied to reproduction. If it's now opened up to people who cannot reproduce, then it's less special, and people are less likely to get married. Okay. Now you may say, Josh, that's stupid, right? That's idiotic. Today, everyone gets married for love. They swipe right. It was beautiful, right? This is why people get married today. Don't laugh. It's true. You know it's true. People get married for love. Who in their right mind would ever consider, well, you know, Adam and Steve just got married, and, you know, I think that their relationship doesn't deserve it. Screw it. I'm not going to get married. Oh, let's talk about divorce rates. Did you guys talk about in property no-fault divorce? Okay, you'll get there. So in the 1970s, California was one of the first states to institute no-fault divorce. What no-fault divorce means is you can get divorced for you don't like each other anymore. Historically, the only reason for divorce were like sex infidelity or abuse or something like that. California said, you know what, we're going to change the regime, make it easier to get divorced. The result of that has been a skyrocketing divorce rate. Now, we can argue maybe that's good or maybe that's bad. Maybe people should be divorced or not. But when you tweak the incentives of how people stay together, it has long-term implications that we can't anticipate. So when no-fault divorce was created, people didn't quite anticipate this happening, right? But it's being used in a much wider manner. So the issue is like this. Do we know for certain, right, that separating marriage from reproduction will weaken marriage going forward? Do we know that? Some people say yes. Some people say no. But there's a debate. There's a debate. Okay. So here's where the courts come in, right? If there's a legitimate public debate about how altering this institution has been around for 3,000 plus years will, in fact, marriage is going forward, is it a legitimate interest of the people to say, you know what, we're just going to go slowly. We're going to proceed slowly. And we're not going to change anything now. Maybe we'll change in 5 or 10 years whenever we get around to it. We're going to do this slowly. Okay? That's one of the state's interests. Okay? Now, Felipe, what's another potential reason why a voter in Texas in 2002 voted to amend the Constitution to prohibit gay marriage, and be a little bit more cynical than your colleagues on the row? What's potentially another reason why they voted for this in 2002?
Because it will demoralize the marriage.
Well, I didn't hear what you said. Repeat what you just said. I think I misheard you.
Well, because the value is not.
Right. That's what your colleague said. Right. Give me another reason of why perhaps some people in Texas in 2002 voted to prohibit same-sex marriage? What, at least for some people, what do you think may have been on their minds? And think Lawrence v. Texas hadn't been decided yet, right? We still had a sodomy. We had our district attorney right here in Harris County prosecute 2 dudes for poorly having sex. What do you think was in the minds of some of the people voting for this amendment in 2002?
Policy lines, like it meant it wasn't accepted, or they weren't accepted.
How do you think that some people viewed gays and lesbians and the actions they do with respect to this vote? Just say it. Sinful, immoral, depraved, an abomination, to quote Leviticus, right? It's in Scripture. Man shall lie with a man, it's an abomination before the God, right? You guys can read your Bible better than I can. So it was no doubt true, right, that some of the people who voted for this amendment in Texas, and I'm sure your parents and friends and others who were of voting age and did it because they thought that gays and lesbians were immoral. And the state should not encourage that sort of behavior. The state should not give its license, right, a marriage license, to encourage this sort of homosexual behavior. Everyone understand me? So, no doubt, there were different reasons why people supported this bill. Some people supported it because they didn't want to devalue marriage. Some people wanted to support it just to maintain tradition, status quo. Others supported it because they simply thought homosexuality was sinful. Everyone okay? You following what I'm saying, right? So then what happens when we have this sort of situation? Some of the interests perhaps are valid. Others maybe you may consider valid or not. I don't know. We can have this philosophical debate. But this case comes to the court. So let's walk through how each of the precedents we discussed in the last week or so contribute to this, right? What did Lawrence say? Right? Even though Lawrence made clear that it wasn't about marriage, no one actually believed that. But Lawrence was not an equal protection case. It was a due process case. And the court said that you have a liberty interest in homosexual sodomy. And I don't mean to put that bluntly, but that's what the holding of the case was, right? You can seek a transcendent dimension of liberty by engaging in sexual acts, right? That as part of your personal fulfillment, engaging in intercourse is a way to achieve that, the intimate acts, as they say. Well, if engaging in the act of sex promotes that liberty, and usually people engage in an act of sex in a broader relationship, then why shouldn't the relationship itself be a liberty interest? You see the building blocks here, right? If the sexual act is itself protected, then of course the relationship between two of them ought to be sanctioned. Okay, and then we move on to Windsor. We discussed this entire topic of moral disapproval. And in the history of the Defense of Marriage Act, the members of Congress made clear, we are enacting this statute that, says for federal law, gays are marriage is one man and one woman for purpose of federal law. Why? Moral disapproval. We disapprove of gay relationships, and we don't want to put the states, the license of the federal government on it. What did the court say there? That such a law, citing Moreno, the hippie case, right? That such a law evinces a bare animus, right? A bare desire to harm someone else. That moral disapproval is simply hating, right? Hater's going to hate, right? It's simply hatred. To judge someone else morally is no longer a rational basis or any basis to support a law. Indeed, the court effectively said, and you can go back and read this, that it's bigoted to not want to give gays and lesbians this dignity, this respect. It's bigoted. The court actually walked that back in Obergefell. We'll get there later. Kennedy was very much more careful in this case than he was in the last one. So let's look again at our state interests, right? Can the people of Texas vote for this because they disapprove of gay relationships after Lawrence and Windsor? No. No. Can the people of Texas vote for this merely because it provides an incentive for society to grow in a certain way? No, right? The relationship of the individual trumps the state's interest in having this sort of responsible procreation. Indeed, the issue of responsible procreation came up during Windsor, and the court said that's not a good enough reason, right? That's not legitimate. So this is why I say the actual decision in Obergefell was so anticlimactic that if you read Lawrence and Windsor together, the building blocks are there. Like it was, little kid with blocks, right? It's the Jenga, right? It's there. If you pull out one of the things, it topples. But this case is a combination of Lawrence and Windsor with a little bit of Romer mixed in for good measure. Okay? So everyone get that much. If you're not still haven't talked a word about the case, we'll get there eventually, I promise. So I want to now go through another argument that Justice Kennedy advances. So Angela, Justice Kennedy makes a point, which I think is historically correct, that marriage has not stayed the same over history. For example, did you guys say coverture in property, right? The idea that when a man and woman got married, the woman goes under the man's cover, and all of her property gets in this this joint block which she has no control over. And women had no rights. Women could be abused. Women couldn't issue divorces. Only the man could. I mean, there are all these evolutions of marriage over the last 2,000 years. So Justice Kennedy asks, why do we stop there, right? What's the argument? Why did Justice Kennedy say we just because marriage has been about men and women, it's changed a lot, right? What's the argument there?
There's a right to marry is fundamental liberty because it is inherent to the individual life.
You're quoting from his opinion. I'm asking you to describe this exact issue. Marriage has evolved, right? So what does that lead Justice Kennedy to conclude? It's changed. We don't have coverture anymore. People now get married for love and swiping right and all this other stuff, right? Why are we stuck in the Kalahari Bush marriage? Why does it even matter? Okay. How has society changed? Through what means has society changed? Cody? Oh, I'm sorry. Go ahead. Sorry. Yeah, go for it. No. You said you were about to start speaking.
Well, before traditionally being a man, usually men back then worked while the female.
Oh, no. My question was, through what means has the law changed? Cody?
I mean, I was just going to say that people's opinions have kind of changed, so that they're more accepting of this.
You're answering a different question. How is coverture abolished? Did you study this?
No, we haven't.
Married Women's Property Act? Does that ring a bell? So you did study it. Liars. Liars. I know what you studied. I use the same book you use. What was the Married Women's Property Act? Roughly speaking. Anyone? Yeah.
So it gives more rights to the woman and getting considered her property.
Good. And was the Married Women's Property Act created by the Supreme Court? Was it a case?
Yes.
It was? Did the Supreme Court enact an act? Cody, want legislation. Legislation. Imagine that, right? Imagine that. Don't tell me you don't know things properly. I know what you're learning, right? We learn the same stuff. Legislation. I think the fundamental failing in Justice Kennedy's opinion is he keeps speaking about the law evolved, but he fails to take any note whatsoever of how it evolved. The Married Women's Property Act was not created by court order. It was created by a legislature. Okay? So if you notice, he uses the pronoun we a lot. We decided and we in this. And then the dissent effectively says that we amounts to 9 lawyers. And I don't know if you noticed this, but the fact they called them lawyers and not judges was very deliberate. It's almost an insult. He called them 5 lawyers. And then Scalia, my favorite, is they're all from the Northeast. No, they're all from the coast. California doesn't actually count as Western. 4 of them from New York. And Justice Thomas from Georgia is the only one from outside. And Chief Justice Roberts grew up in Indiana, so he's like the only middle, the vast between, whatever he called it. Okay. So Kennedy's entire discussion about how rights evolve, leading up to Lawrence. Of course, after Lawrence, he's running the show. But leading up to Lawrence, he describes all these evolutions in the law. And I sincerely think he sees no difference between when the law changes by court and when it changes by legislature. I think he sees absolutely no difference. None whatsoever, because he doesn't distinguish between the two. And then we get to Bowers, right, which was overturned by Lawrence, right? These were his decisions. So we basically have legislative change and then Tony time, right, where Kennedy decides what goes. Okay. So then we move on to discussion of how do we identify the rights that are protected by the 14th Amendment. So there's a case which I don't assign, because I don't have time, but I usually would, which I don't anymore, is Washington against Glucksberg. Okay. This was actually an interesting case involving the right to assisted suicide. Remember Dr. Kevorkian, if you can remember that far back, where can someone go to a doctor who's terminally ill and ask the doctor, please execute me? Please give me a sedative to make me die in a non-painful manner. By the way, query, why are executions so much more painful than assisted suicides? Because the drug companies won't sell the good drugs to the states who want to execute people, right? Assisted suicide can be done painlessly. Why can't you do the same for a person who wants to be executed? Because the states will not get access to the good stuff that'll kill someone painlessly. That's why they have to make their own cocktails where people get burning sensations, right? There's a de facto war against the death penalty, which makes it impossible to get stuff. I mean, if you're in various Scandinavian countries, you go to a doctor and they can put you to sleep in a few minutes. It's not very hard or painful. But for executions in the United States, different story. But in the case of Washington against Glucksberg, there's a question of whether you have a constitutional liberty interest in assisted suicide, right? Can you have this sort of liberty interest in assisted suicide? And the court said no. But the reason why the court said no is helpful. The court said, look, when we're engaging in substantive due process, right, we can't just make stuff up. We can only find those rights that are rooted in our history and traditions, right? Rights that are deeply rooted in our history and traditions. So assisted suicide is a new right, newfangled right. Justice Kennedy never liked that opinion, and in fact, he never actually cited it in Lawrence quite deliberately. Because is the right to same-sex marriage deeply rooted in our traditions? Of course not. It's like 10 years old. And around the world, it's maybe 15 years old. It was invented in 2000 in the Netherlands, I think. So Kennedy does not take a historical approach to identifying rights. Instead, he adopts something. I'll read this. I have it highlighted in my notes. When new insights reveals discords between the Constitution's central protections and receive legal stricture, a claim to liberty must be addressed. I'll read that again. When new insight reveals discord between the Constitution's central protections and receive legal stricture, a claim to liberty must be addressed. Charles, what the hell does that mean? I read it twice, so they have no excuse. Right? What does that mean? I have it highlighted with the WTF next. What does that mean?
You can do the first one.
No. Next, I'll come back to you. I can't read it again. It's too much. Danielle, what's he talking about? Did anyone actually listen to me? Raise your hand if you actually listen to me. Okay, yeah.
Oh,
Yeah.
yeah.
I'm not up for my own help.
I listened.
Does anyone actually pay attention to what I just said? My God.
I mean, so saying that there's like received legal stricture. So for a second, I thought you said legal scripture. Legal stricture.
That's a legal scripture, right? Stricture. All right, fine, I'll do it. You guys are worthless. Okay. Stricture. It's make control like a structure. So let me give it a stab. When new insights, right? In other words, when people start seeing things they haven't seen before, when there are new dynamics. In this case, the idea that gays and lesbians can have loving, caring families. This wasn't even conceivable in the past, right? This was beyond, it wasn't even imaginable. When these new developments come into conflict with pre-existing traditions, a claim to liberty must be addressed. a claim to liberty must be addressed. All right, Charles, redeem yourself. Who addresses that claim of liberty? Notice he always uses passive voice. He loves the passive voice. I hate the passive voice, right? Who addresses that claim of liberty? Not Roberts. Kennedy, yeah. The court. Well, same thing. So what Kennedy's opinion is basically saying, and again, you use the word living constitution. I really don't care what words you use to describe it. As our society matures, we see injustices that were not seen before. We see people whose dignity was being demeaned that we were not aware of before. And when that harm runs into our traditions, like marriage, strictures for John, right? When that harm runs into our strictures that have been around for 2,000 years, the court then addresses which shall prevail. Okay? But the initial question I asked is somewhat circular, right? How does the court, and this will be for Daniela, how does the court, according to Justice Kennedy, decide what is a liberty interest? Like what makes something worthy of balancing the state's interest versus these new awarenesses? What is this? Well, what's interesting is Kennedy doesn't really use a fundamental rights approach. The reason why is because the test is that Glucksberg case, the assisted suicide, and historically fundamental involve rights that are rooted in tradition and history. Right? That's where those rights were protected. So Kennedy's not looking at tradition to decide fundamentality. That's a good word. What is he looking for? It's a difficult question because there's not really an answer, but at least try. What is he looking for?
The individual's autonomy
As assessed by whom?
by the person.
Which person? Did Jim Obergefell write this case? You're on the right track. Want to accept?
So I take it as it was their liberty and from the perspective of the person who's claiming to have not received or not entitled to that liberty.
But ultimately, who evaluates that claim?
Well, here the justices.
The court, right? So the long and short of it is that tradition and history are not relevant here. Kennedy says if we limit ourselves to only those rights that are rooted in tradition, same-sex marriage is not protected. But isn't that the issue, right? Isn't that circular? The entire question is whether same-sex marriage is a fundamental right. Kennedy's analysis puts the cart before the horse. It determines the outcome before it begins. He says because tradition gets in the way of same-sex marriage, we don't look to tradition. Right? It's irrelevant because it doesn't protect this sort of right, which we deem very important. The rest of the opinion doesn't matter. I'll go through it, but after that, it doesn't really matter. You have to read all those pages for not. But it doesn't matter. He identifies these 4 characteristics out of thin air, about why marriage is important, that it's inherent in the concept of individual autonomy. I suppose. So what? I don't know. There's a dignity in the bond between 2 men and 2 women who seek to marry, and there are times to make profound choices. Okay. The right to marry supports persons. Reflects a commitment between 2 people. It's a noble purpose. It dignifies couples who wish to define themselves by their commitment to each other. Merely allowing them to engage in sexual acts is not enough. These are my favorite lines. Outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. And if you see the circularity, he's defining liberty with respect to liberty. Right? It's dignified because it has dignity. The entire opinion is circular. And in fact, I just read this the other day. There's a book you can buy. It's called, what else is it called? What Roe v. Wade Should Have Said. What Roe v. Wade Should Have Said. What the book is a bunch of law professors who got together and they said, you know what? We agree with the outcome in Roe, right? We favor abortion. Everything's great. But the opinion was awful. So they they asked a bunch of law professors to rewrite the majority opinion based on the law as it exists in 1972 or through whatever year it was. Okay? So what Roe v. Wade should have said. I was waiting for this, and it happened. So a conference was just announced. What Obergefell should have said. So basically, not even 6 months after the decision, the law professors are already saying, oh, this is crap. We have to do something better than this, right? We have to write an opinion that actually justifies why this right is so important. One of the dangers of having these fluffy opinions with language doesn't mean anything is it's not to be taken seriously. And I try very hard to actually, that's why I started 30 minutes of explaining the issues, right? There's not any discussion of whether gays and lesbians are suspect classification. None. Strict scrutiny applies, who knows? There's no discussion of how getting a piece of paper is a constitutional right, other than the fact that it demeans you. How does the case affect the next one? Can a baker refuse to make a cake for a gay wedding? Does a constitution prohibit the state from discriminating against gays and lesbians in employment? We don't know. There's so many important issues that are not resolved here. It reads like an awful poetry thesis, right? That, you know, someone just wanted to write about poetry and philosophy, and he didn't do a very good job. So regardless of how you view this issue, the opinion leaves so much to be desired. And that's why you'll probably see next year at this time, a bunch of really smart law professors write an opinion. Let me tell you what a good opinion was. Judge Posner, right? Judge Posner. His opinion was like 20 pages long. He's usually very curt. He writes the opinions in one sitting. He just types them out, not even his clerks. It said, look, under the court's precedents, it's obvious that gays and lesbians are a heightened classification. Under strict scrutiny, these laws fall. Donezo. Done. I mean, you can read it. I mean, he has a couple of jabs here and there against people who don't like gay marriage, but whatever. It's an opinion that reads like a judicial opinion. There are other opinions from courts of appeals that said, you know, under Loving v. Virginia, marriage is a fundamental right, and you can't deprive gay couples of this fundamental right. Right? Done. There are dissents too, but they try to read like a legal opinion. This does not read like a legal opinion, but the stigma and dignity and demeaning, I mean, these are all very nice things, but what the hell is a lower court supposed to do with it, right? What's a law student? You're sitting here in my classroom right now. What are you supposed to do with this, right? If you have to make a case for a client, how are you going to make an argument? If, say, your client is a, I don't know, a state employee who was fired because he was gay. This happens. What the hell is your argument going to be? That this demeaned his dignity? The lower court's going to laugh you out of court. That's not a legal standard. There was a stigma to my client that he was fired for, you know, hurt his feelings, right? You guys are going to be lawyers in a couple of years. Right? So this is what drives me nuts about this case. And I don't mean this, the merits are respective. Go read Judge Posner's opinion. Came out the exact same way, but actually read like a judicial opinion. Yeah, Dan.
Would you go as far as to make a case that perhaps Kennedy and the justices that supported this engaged a little bit in social engineering rather than law?
I don't know. What do you mean social engineering? I don't know what that is.
Well, it proposes to redefine relationships or to bring, for instance, gay relationships into a different light for society to understand. And based on that, it proposes that's why this opinion should be accepted.
Ah, okay. So actually, I was going to get there in a minute, but I'll do it now. Part of the opinion by Justice Kennedy, and I'll skip equal protection because there's no analysis there. It's just, I'll do it briefly. Justice Kennedy doesn't actually like the clause of the Constitution. Equal protection and due process, they're different clauses, but he reads them together. I've actually described this like a double helix. They kind of wrap around each other like a snake on a staff, right? The text of the Constitution is entirely and utterly irrelevant. He doesn't view equal protection and due process as different inquiries. Okay, so you have a client, and you go, Your Honor, may it please the court, this violates equal protection and due process. Why? Well, they're really the same thing, Your Honor. Get out of my court. Right? I want you to actually think about this because maybe you'll do civil rights work one day, you do labor, whatever. This is not any effort to be law. Okay, but I want to answer Dan's question now before I forget it. There's a big movement, right? A book called We the People by a guy named Barry Friedman, written a number of years ago. not really, what was it called? The Will of the People. Sorry, Will of the People. And the thesis of the book is this: that the Supreme Court never pushes too far ahead of public opinion, and they always try and lag, like a caboose on a train. They always try to lag on the back and not move too far ahead. So the Supreme Court wasn't ready to invalidate gay marriage in 2009, but by 2016, close enough, 50-50, right? Enough states probably support it. And indeed, before Obergefell, nationwide, it was about 50-50. Maybe not in Mississippi, maybe it was a little, but nationwide averages was about 50-50. So there was the argument that Justice Kennedy says is, do we proceed with caution, right? Can we just wait for the legislative process to work? Okay. He says no. And this is the part that boggles my mind. He says, let me read this. There have been deliberation, referendum, legislative debates, grassroots campaigns, as well as studies, papers, books, popular and scholarly writings, tweets, and blogs. No, I meant the last part, but may as well have been there, right? Justice Kennedy thinks because this has been so widely discussed, the issue is resolved. Even though only 12 out of 50 states had legalized gay marriage, a lot of others did so by courts, which is not legislatively. 12 out of 50 states had done so. Kennedy thinks the debate's over because there have been popular and scholarly writings, debates, and books. So the debate's over. So, whatever. He believed that the debate has been happening enough. And in large measure, what triggered the debate? Romer, Lawrence, Windsor. That with respect to this issue, the court's been at the forefront at every juncture. Not as the caboose, but as the locomotive, pulling the issue forward. And at every juncture saying, oh, but this doesn't mean gay marriage. And, oh, this doesn't mean gay marriage. No, this doesn't mean gay marriage. But then, oh, yeah, just kidding, it does. This new awareness, right? We have this new awareness because these books and blog posts that we have seen. And when there are fundamental rights, they don't depend on the outcome of the vote. So, he says this. So I encourage you, actually, if you want, go read Judge Posner's opinion from the Seventh Circuit. It reaches the same result, but actually applies law. And again, this is in no manner a comment on same-sex marriage in any respect, but the actual legal precedent. I'll send you guys a link to Posner's opinion later. I should have done that earlier, I forgot. But I'll send you guys a link to Posner's opinion. It's not long. It's actually somewhat. It's Posner. It's an enjoyable read. Yeah.
So I mean, it's sort of a trend here with
Oh, that's what Justice Scalia said, isn't it?
Why do they keep assigning him? Is that the only way to get him in?
So, that's a very profound question. How are opinions assigned at the Supreme Court? Okay, so the most senior judge in the majority opinion gets to assign the case. Case, and who's the most senior judge in the Obergefell majority?
It would have to be Breyer.
No. Who appointed Kennedy? Which president? Who appointed the next one? Ginsburg. So who's the most senior judge? So Kennedy has basically assigned himself every one of these opinions. And let me tell you, the other judges don't give him any edits because they don't give a damn. It's like, I don't care, Tony, whatever you want. You could use this as toilet paper and I'll sign it, right? I'm only saying facetiously. I would have loved to see Justice Ginsburg write this opinion. I would have loved seeing Justice Kagan write this opinion. They wrote such a strong opinion for the ages, right? And then we have this. So Kennedy writes this. No one edits this because they don't fear. And if you notice something, he never responds to the dissents. He doesn't respond to the dissent in Lawrence, not in Windsor, not in this. It doesn't matter because debate's over. Debate's over. It's over. It's done. We did this. We have blogs and we have book posts, right? We've had the time for debate has finished, right? It's done. Time to debate is finished. Yeah.
Also, was there ever any pressure on Ginsburg to refuse given what they initiated?
Okay. So before Obergefell, Justices Kagan and Ginsburg actually officiated a number of same-sex weddings. So there was a movement to have them recuse. I don't think that was ever going to actually happen. If you actually want to be precise, they performed them in jurisdictions where the process was legal. So it wasn't like they were taking a position on whether it should be legal in other states, but you could draw your inferences from there. But yeah, good, very observant question. Okay. I want to turn to the, oh God, what page is it? It's the thing about religious liberty is because we're going to talk about First Amendment next week. I think it's on the, if anyone has a page, just shout it out. There's a paragraph with the First Amendment. Anyone have it? It's like 25 or 26. Where the heck is it? Not in the Constitution, in the opinion. You guys are looking in the wrong place. Oh God, sorry, I should have had this ready. Oh God, okay, I'll go, here it is. Okay, so on page, bottom of page 17. So at the bottom of page 17, the opinion. Okay. One of the big issues in the aftermath of Obergefell that was heightened by the fact that he didn't actually address any of the important questions is that of religious liberty. And we'll be discussing this starting, oh God, I think the last day of class. I wish I had more time for you guys. It kills me I have to rush this stuff. So Justice Kennedy says, look, I know there can be some religious liberty issues, but guys, you know what? Don't worry. Everything's going to be awesome. I'll tell you why. The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and to their own deep aspirations to continue the family structure they've long revered. So he's saying, look, we're not going to come after your families. You guys do you, we'll do us, and everything will be fine. But what about actual issues that matter? So during oral arguments, I think it was Alito raised a question, said, okay, what if you're a Christian university and you offer housing to married couples? And then two men at your university get married in the state they live in, and they ask for a married dormitory. And the college says, no, we deem that relationship sinful, and we will not afford you a married room. The Solicitor General of the United States, Don Verrilli, I've mentioned him a number of times. Know what he said? Know what he said to that question? That's going to be an issue. Yeah, I think it said literally, that's going to be an issue. So this hollow praise for religious liberty doesn't get you very far. Perhaps more importantly is the issue of tax-exempt status. I promise you, in your very near futures, you will see jurisdictions, not the federal government, but states and counties start to yank tax-exempt status from churches and other groups that don't treat gays the way the state would like. You'll see it. I promise you. Not the IRS, but local counties have property tax, right? Sales tax exemptions for churches. You'll see this. And nothing in the Obergefell opinion says otherwise. The court at least says that opposing gay marriage is not driven out of animus. This is actually a reversal from Windsor, where they said those who have moral disapproval or engage in a bare animus to harm. The court pulls back from that language a little bit, but not slightly, but not a lot. So at least all of you people who perhaps oppose gay marriage will know that you're not a bigot. Mazel tov, congratulations. But know that you are stamping and demeaning people. That by opposing this, you are treating them just as Virginia treated an interracial couple. That by opposing same-sex marriage, you are no different than the segregationists who passed the Racial Integrity Act in 1924. So this entire thing is like, oh, there's no animus, but you guys are a bunch of, you're just like the segregationists. So that, to Dan's point, that sends a signal too. Because if someone raises an argument saying, I don't like gay marriage because of my religion, well, you're just like the segregationists. Thank you, Justice Kennedy, right? The last paragraph on page, okay, what's the page? It's on the bottom of page 18. I think there's make beautiful wedding vows, but not very good law. So it says, No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. So for all of you single people, you're really missing out, right? You cannot be fulfilled as a person unless you are married. Okay, I guess I'm doomed to a life of indignity, okay? In forming a marital union, two people, why not three? Well, no. Two people become something greater than what they once were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. Okay? It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them this right. It is so ordered. Indeed, so ordered. Afterwards, there's this long appendix. You probably have never seen an appendix in the opinion. This I thought was gratuitous, but whatever. They listed every single decision addressing same-sex marriage. Just like a shout-out list, right? This is giving credit to the lower court judges who did what is deemed correct. And these are all the decisions affecting same-sex marriage, going back to 1982. All these. And the first one starting, you see Windsor, and then you see all these Ninth Circuit decisions and everything else. And the district court decisions, the first one was from Utah. I mean, they keep going and going and going. All these judges who did what they perhaps were supposed to. Oh, the state courts too. I'll list all these. Yeah. And then Appendix B, all the legislation that actually adopted gay marriage. Notice how few statutes there are. Like there are 3 pages of cases, and it's like half a page of statutes. And all these judicial decisions. Okay. And I'm not giving thrift to the substance, but just this opinion saddens me as a constitutional law professor because there's nothing to teach. There really isn't anything there, and it breaks my heart because I was really hoping for like a Ginsburg or a Kagan. Like Ginsburg opinion VMI, that was a solid opinion, right? There was a lot there. Had you just done the same thing here and said heightened scrutiny, done. Yeah.
So this is extending to state like action, not necessarily private action. So private individuals can still discriminate on the basis of race or on the basis of sexual orientation, but states can't pass laws that are restricted.
Let me ask you a question there, Randall. If the state passes a law saying that you can't discriminate on the basis of sex, and all laws have those laws, all states have those laws, does that include sexual orientation? The states even have to change their laws? So the EEOC, the Equal Employment Opportunity Commission, has reinterpreted Title VII. Title VII is a law passed in 1964, 68. It's a 40-year-old law. And they've said that to discriminate against someone because of their sexual orientation or gender identity is to discriminate against them on the basis of sex. Therefore, we already have laws protecting this. So actually, parallel to these decisions of the court, and actually bolstered by these decisions of the court, the government, the current government, is now treating sexual orientation or gender identity discrimination as sex discrimination. So in effect, it's already illegal.
Good question. So with this logic, how can we draw a line between same-sex marriage and 3 people on getting married, or any other aspect of Kennedy's logic? So is there no
That's an oxymoron.
correct?
Any logic.
With Kennedy's logic.
Oh, go ahead.
So there's no definition for marriage,
Well, you keep saying 2. The word 2 appears a couple dozen times. You're saying 2 people.
but it's not an accurate definition. It says 2 people. Shouldn't say an woman. So
I think this answer is for Scotty. Sister Wise, I'm sorry.
No, I had a question to follow up his.
Oh, okay. I'm sorry. I thought you wanted to answer it.
No, I wasn't gonna touch out a 10-foot pole.
Is that how far your house is from the Sister Wise house by a 10-foot pole? Sorry, that was mean. I'm sorry.
But I was gonna say, because this opinion is so open,
I'll get back to you in a second. Yeah, go for it.
because this opinion is so open-ended, it's so vague, it contains such, flowing language. Couldn't this be used to open the door for the transgender rights movement, and this be a building block on their civil rights movement? For bathrooms and their crusades. I feel that this is right up Kennedy's alley, and this is just a stepping stone in that movement as well.
So the point I made a moment ago, I'll answer both of your questions. The federal government, the administration has determined that high schools that restrict access to locker rooms to students based on biological identity are running afoul of Title IX, which prohibits sex discrimination. So you don't actually even need the Constitution to get there. Once courts start holding that these laws restricting gender discrimination include sexual orientation and gender identity, you don't even need the Constitution. These laws are already in effect. And to Tariq's question, which I graciously skipped over for a second, this is a point the Chief Justice raises. Whatever arguments you can apply to 2 people can apply to 3 people or 4. Perhaps there are arguments that the risk for abuse is greater when you have a polygamous relationship. Maybe yes, maybe no. But if indeed it's about love and fulfillment, you can police in other ways, right? Make sure the police check in on that, make sure that there's no allegation of abuse, maybe make it easier to get divorced. There are different ways. But prohibiting the union period seems to consist. Now, just a week ago, the Sister Wives case I told you about last week, the district court found the law was unconstitutional. The 10th Circuit basically avoided it. This case will come to the Supreme Court, and I'll bet you $100 the court does not grant certiorari. Kenny does not want to touch this case because that makes his entire house of cards fall apart. They're not going to touch this case. You think the love and fulfillment of the Sister Wives, they love each other, you think? Yeah? They're happy? Do you think they're actually happy off camera?
Some more than others.
Some more, so yeah. Sister, right. Okay. Other questions? Oh, yeah, 1 and 2, yeah.
Okay. In reading the opinion by Kennedy here, there's been several aspects of the 14th Amendment. There's been, race discrimination, gender discrimination, and now the same-sex marriage. It's almost as if he's affording a broad protection to same-sex marriage by not limiting it to a test of strict scrutiny, where those other classifications are limited by a test. I mean, is that?
That's exactly the point, right? And this is why I said before, what is a lower court judge supposed to do with this, right? And I said, you have a gay client who's dismissed by the state employer. You say, Your Honor, this infringed my client's dignity. They're going to throw it out of court, right? I mean, you guys are going to be lawyers. I mean, this is not a hypothetical exercise. This is not a test. Doesn't read go read the Posner opinion. It's very rigorous. I mean, it goes through doctrine very quickly and explains it. The entire opinion is not very long. He wrote it like in 2 weeks, maybe even less. Like within a week or 2 of arguments, the opinion came out. It was insane. By the way, if you want to ever hear a lawyer destroy an advocate, Posner's arguments in this case, he was destroying the state's lawyers. I mean, it was brutal. I thought it crossed the line, but he's a dick. So he actually tells you the same way I say call you Josh, he says call me Dick. He insists on first name. He's a very interesting dude, very interesting guy. But read his opinion and you'll get the doctrine down.
So other courts.
I think there was a question there first.
You keep saying, you're making the point that obviously there's not as many laws on the books as just judicial decisions. So your problem, or your scrutiny of Kennedy's argument is that in a way they're being both the legislature and the court because they're enacting the law and they're interpreting it when isn't it their job just to interpret?
So let me answer the question this way. In Lawrence v. Texas, right, Kennedy noted that by 2003, virtually every state had repealed their sodomy law, right? And only a couple had, Texas and Mississippi, whatever. And even the states that had it hadn't enforced it. And Kennedy used the fact that virtually every single state has repealed this as evidence that this is where the Constitution is moving, right? I don't have to accept the argument, but has a certain appeal to it, right? If 47 states have repealed the law and no one's enforcing it except for this idiot Chuck Rosenthal in Houston, right? It's probably not a very meaningful law at this point. But here, it's the exact opposite. Only 12 states had repealed it by statute. And as this chart shows, the issue is very divisive. So the trend line doesn't flow. So it's not even a matter of legislating and judicial, but the argument doesn't hold up on its own weight because whatever trend existed for the sodomy laws didn't exist. Now, if you wait another decade or so, I sincerely think if the court had ducked the issue in Obergefell by 2020, I think just about every state would have had same-sex marriage. I mean, I can't say that confidently, but I can say with a high degree of certainty.
Even that you have a different 20 years from now you have a whole different set of representatives.
And voters.
And voters.
Yes.
I felt like it came a little early because I felt like what you're saying is that overstepping their bounds to what they're able to do. They're supposed to only interpret, and in this way, they're taking what people think at this time and applying it without the legislature being there.
Good. I saw a hand there.
So, I mean, granted, this is nothing more than a Hallmark card.
This would have been rejected. It's too long for a Hallmark card. It wouldn't fit.
Well,
This is like Americans Greeting, like the second-rate one.
thanks for a few.
The CVS generic brand
But
card.
doesn't it, in a way, take away the power of state legislature to evolve on their own?
Yeah, this cut off the debate. I think the chief made this point too. The debate's over, right? Once this happened, there was no more debate. It's over. Anything else with regards to the dissents? Yeah.
So, concerning the issue here between the majority and the dissents on the role of the judiciary in this case, the dissents are arguing the democratic process was working, and we've stripped them of the ability to reach this lofty goal through the democratic process. And the other side is saying, well, that may be true, and there has been a discussion. We've determined that this is a right, and because it's a right, they cite other cases saying part of the Constitution is that liberty doesn't have to depend on the democratic process when there's an infringement on a right. So, and I agree, they totally disregard the equal protection stuff and don't really go through the same analysis of saying, yeah, this is a fundamental right, and here's scrutiny, and this was not a good law, so we take it away. So how do you, moving forward, how do we...
On the exam, as the next question. Like,
yeah. How do we that? My up through now, what I would do on the exams, I would say, well, this is treating this class this way in this law, so scrutiny should be this, and as a result, the ends and means don't fit right.
Welcome to my world.
So
this is like the $1 million question, right?
I realize that you're sitting in this class taking exam, but you're also living through history, right? What is the state of constitutional law anymore? Is dignity the new scrutiny? I don't know. We won't know until the next case that comes up. So, I mean, to answer your question in the short haul, for the exam, I think you should at least discuss scrutiny and apply it and do what we've done before and try and see if a right's fundamental. But going forward, what was once black letter constitutional law, as long as Tony's in charge, may not be. And I realize that's not the answer you want to hear, but I'm not just teaching you for an exam. This is stuff that affects every one of you and virtually every aspect of your lives, whether you realize it or not. I don't have an answer to your question. I don't know. I wish I knew, right? We're now in this world where we don't know what the law is until the next decision comes out. That's very, very confusing, and for students, let alone. Right? All these case books are having to figure out how to put Obergefell into their horn books. These outlines are all wrong now. But yeah, I don't know. The question is the majority opinion. Yeah.
So what's do individuals have a right to dignity outside of classification?
What's dignity?
So dignity is like a positive liberty right. So the ability to engage in certain conduct and have certain protected status.
Where are you getting this from?
So partially from Kennedy.
No, I know, but good. That's a good answer, actually. Very good answer. Where's Kennedy getting it from?
Philosophy.
Philosophy. The philosopher king, right?
Yeah.
So right. So is, if I can paraphrase your question, is dignity now like a central component of constitutional law? Is that what you're?
Like, can I go and argue that as an individual I have a right to dignity, and so that has been demeaned in certain situations? Or
Give me an example of what situation where your dignity is being demeaned, other than me, giving you a hard time at recitation.
In a job situation, or it could be like in the criminal court system,
like the judge looked down on you, and that's violated your dignity.
Process in a certain situation.
Oh no! Use an actual constitutional word. Due process is a word in the Constitution. Right. Dignity is not.
Right. So, but under due process, the test is dignity.
Well, let me give you an example, right? So I'll give you an example. This is an example we've said before. So the court has held that you don't have a right to welfare, right? That the Constitution does not require a minimum level of income. but my dignity is impacted because I don't have a house. My dignity is impacted because I don't have a safe place to live. The state owes me a positive obligation to give me housing. And if the state doesn't give it, I could sue them for violation of the 14th Amendment. Can you make that argument with dignity? Sure you can. Will court accept it? I don't know. But this is the sort of thing. If you read Kenny's language and you substitute marriage for housing, right? Or marriage for employment, or marriage for welfare, right? Not having a job, not being employed hurts you a lot more than not being married, okay? If you don't have a job, you're on the street. If you don't have a minimum level income, that hurts you a lot more than not having love and marriage and whatever else stuff, right? With respect to married couples. Not having a house, I can live without a spouse. I can't live without a house or an apartment or whatever other structure you live in. So there are some people who are absolutely thrilled by this opinion, that this will open up the door to various positive constitutional rights. Now, this is Thomas's dissent, but you said, Randall, positive constitutional rights. What does it mean, positive constitutional rights? I want to make sure everyone understood what you said.
So the right to do something as opposed to the right to be free from.
Ah, very good. So there's this idea of a positive versus a negative right. Okay. Just as Thomas makes his point, historically, constitutional liberties were viewed as negative rights. The right to be left alone. Go read the Bill of Rights. Congress shall make no law of this. Congress shall make no law of that. You can't infringe this. You can't infringe that. Does it say you have the right to free speech? No, it says Congress can't infringe it. You have the right to bear arms? No, Congress can't infringe it. Our rights, as the Declaration said, by the way, yesterday was Thomas Jefferson's birthday. Happy birthday, Tom. As the Declaration said, I was at Independence. I was at the National Constitution Center yesterday, so it's right across the street. But as the Constitution says, or Declaration, our rights come from someone else. Government does not give us rights. Government exists to check itself. That's why we have a Constitution. A positive right is that the government's right to give you free stuff. A marriage license is stuff. Welfare is stuff. Housing is stuff. And education is stuff. And the court has held consistently that you don't have the right to stuff. Right? The government can't criminalize you for sodomy. They can't criminalize you for giving birth control, but you don't have a constitutional right to birth control. You don't have a constitutional right to abortion, right? If you can afford it yourself, great, but the government doesn't have to pay for it. But this opinion alters that calculus. This opinion says that you have the right to stuff. You have the right to marriage licenses. And to deny you a marriage license, to deny you a tax-exempt status for your spouse, to deny you, I don't know, whatever the heck it's going to be, to deny you various benefits given to spouse, sharing Obamacare, whatever it is, right? That is actually a violation of rights because it demeans you. Because if the opposite sex couples have it, you don't have it, give this right to it. So this opinion is a radical departure of the court recognizing a positive right to stuff. And Justice Thomas's dissent makes that point, I think, quite clearly. Did I answer your question, Randall?
I mean, to the best, I think that they're able
To the best of my ability? Okay. Other questions? Yeah, Mirza.
Yeah, so there is I had a question on the snap by Scalia comment. There's a quotation in there that said, slaves did not lose their liberty because the government allowed them to be enslaved. Human dignity cannot be taken away by the government. What do we make of that based on our reading of the case?
I think that's what Thomas's dissent, John, basically. But yeah, so this actually quote actually pissed off George Takei. Everyone know George Takei, the old Star Wars guy? He's on Facebook. I don't know. He's right, whatever. He has funny memes, right? Did I say Star Wars? Oh, Star Trek. I'm right. Thank you. So one of Thomas's points is dignity is not given by government. Therefore, it can't be taken away. Thomas actually cites the Declaration for the proposition that we are endowed by our Creator with this humanity. The government cannot remove this humanity from us. And that no matter how awful a slave was treated, or no matter how awful a Japanese person in internment camps was treated, he still had his dignity. Okay? He still had that humanity that God gave him. What he's actually making the point there was not to, whitewash slavery, but to make the point that dignity cannot come from government. and the government cannot give us free rights. That all government can do is check itself. This is a foundational dispute over what dignity actually is, what I asked Randall a minute ago, right? If you believe that dignity is endowed by a creator, then this entire opinion is fluff, which is what Thomas would say it is. If you believe that dignity is actually conferred by the government, by giving someone a marriage license, you would give them dignity, then the majority makes sense. This is why I asked Randall, what is dignity? And he gave me, I thought, a very strong answer based on Kenny's opinion, but this is a concept that's actually very prevalent in European courts. I think the German Constitution, don't quote me on this, but I think the German Constitution actually guarantees the right to dignity. So it's actually in their document, right? They actually wrote it. We don't have this. But Justice Kennedy is widely influenced by European courts, and he's, importing it, I should say. Other questions?
How do you enforce the right to dignity?
So ordered. It is so ordered.
Well, it just says, but now it's sort of anybody can wave that flag.
Well,
So with everything else so ordered?
wait just a second. Want to answer this question?
I want to answer that.
Okay.
Don't tort actions-
This way. No, sorry, this way.
Don't tort actions protect against affronts to human dignity? Is that not?
How are tort actions created? No, I mean, most states have adopted the restatement of torts, have statutes governing tort law.
Yep.
So who decided that dignity should be protected?
Prosser and Keenan? I don't know.
Prosser and Keene were law professors, but they didn't do it themselves. Governments have to adopt those laws. So the point is, we indeed have torts that infliction of emotional distress, right? Libel, slander, defamation. Governments create various torts that may impact a person's worth. Those are not from the 14th Amendment, last time I checked. Is your hand up, John? I think you were like inching.
Yeah, the question was a little bit more on Thomas's dissent.
Please, yeah, go for it.
Dignity is not given by the government. That also seems like something that's also a statement that's also not based on the Constitution, right? Like, so
It's based on what?
is that his own personal beliefs?
No, the Declaration.
Oh, Declaration. I'm sorry, the Declaration. But that's still an interpretation of something that's not the Constitution, and it does seem like the court is just both sides. It seems like are equally along to non-constitutional reasons to sort of say things, and I guess that's probably what worries me most.
So what would your approach be to dignity?
I mean, I'm not sure I would mention it. I would not sure scrutiny.
So you think that Thomas should not have even engaged in dignity discussion at all?
Yeah,
Okay.
because
Fair
both
point.
sides, even if you go on the other side, then, so for example, when we get to religious liberty, we can talk about whether or not the dignity of religious institutions are being violated by, same-sex marriage and stuff like that.
It goes everywhere, right?
Exactly. Dignity, dignity is being violated one way, and they basically have to weigh them and figure out which one's more. And then you go back to the fundamental test or something, or you go back to strict scrutiny, or some other way to, balance out or make a decision based on both competing agreements.
Good. Fair point. Who else? Let's talk about the Chief's dissent for a few minutes. And again, this could be an entire 3 classes. I could just do 1 class in each of the opinions, which is why I force you to read 100. See, it actually looks like it's 50 pages. That's with a small margin. It's actually 110 pages in the full print. So I tricked you. If I give you the full 100-page version, you wouldn't have read it. So that's why I put the Westlaw version. It looks smaller. I deceived you deliberately, with small font and everything. I know how this works. So the chief says, "Look, I don't begrudge your celebration, but for the rule of law, this is a bad day. 5 lawyers, again, not 5 judges, 5 lawyers, have closed this debate and enacted their own vision of marriage." So to summarize, Justice Roberts, in one word, Lochner, right? I lost count how many times he cites Lochner. Lochner this, Lochner that, Justice Holmes this, Justice Holmes that. Roberts views the idea of substantive due process as this sort of tragedy that the court, in a previous instance, tried to substitute their wisdom for that of the legislature. He views this as the Lochner case, right? That they decided that this law was not really about protecting workers; it was about protecting big bakers, and that this is not a role for the courts to participate in. He views this of the same order, and indeed far worse. So rather than striking down a Baker law, the court's neglecting a tradition that's existed for thousands of years, millennia, right? Long before we had a constitution or a declaration or even a New Testament, right? This institution has existed before that. And it violates the role of the courts. Let's see. It also walks through precedent, but we already disagree with that. For good measure, he cites Dred Scott. Of course, Dred Scott was one of the first Supreme Court cases that applies substantive due process, the actual right to own a slave. And where did the court get this from? Well, Roger Taney's vision of what liberty ought to be. So Roberts doesn't dissent very often. When he dissents, he doesn't write it. Here, he brought out the big guns. So you have Lochner, you have Dred Scott, and then he says that the precedents in no way support this. Back to Lochner again, talks about polygamy. He says the court does not engage with equal protection. He says, frankly, I don't even understand it. You're not alone, John. The equal protection analysis, he doesn't give much. Towards the end, this is a theme we've discussed with the chief a lot, legitimacy of the court. I think of his Obamacare decision. He didn't want the court to be on the 5-4 decision that changed and altered a major social structure. And for him, it cuts the same way. He doesn't want to strike down Obamacare, and he doesn't think the court should be in the business of striking down marriage laws in 45 states. He says courts should exercise humility and restraint. He also makes another point that I think I mentioned before, that there's a liberty interest that is not spoken for here. And that's the liberty to govern ourselves. The Declaration of Independence says one of the greatest grievances against the king was that we couldn't pass our own laws. We couldn't govern ourselves. And we fought a revolution so that we can govern ourselves. But to Roberts, the court's decision takes that power away and gives a governing structure to 5 lawyers. Again, they keep calling them lawyers, which is it's a striking reference. And one of my favorite, if you read the footnote, I think it's footnote 24, Scalia. The footnotes are at the bottom, unfortunately, where he said, I would rather put my head in a bag than join this majority opinion. He was saying that Kagan and Ginsburg should be ashamed for joining this tripe. That at the expense of getting a 5th vote, they joined this awful opinion. They put their heads in a bag instead. Okay. Also, Roberts makes a point about religious liberty, how the fact that these questions of tax-exempt status for Christian universities is up in the air. And then Roberts closes by saying that this attacks the other side of the debate. To say that those who favor traditional marriage are stigmatizing or demeaning people, imposing dignitary wounds, this is a serious, serious charge. And he quoted from his Windsor dissent, the majority paints with a brush of bigotry. And now if there's ever a debate over this issue, people say, look, Supreme Court, you guys are bigots. That's it. Ends the debate. So Roberts would celebrate the decision, but not the Constitution. Or to go back to my friend Jim, love indeed won, but not the law. I saw a hand somewhere there. Okay. Any questions in the Roberts? Yeah, John.
Is the liberty to govern ourselves, is that a positive or negative?
Oh, I think that's a structural right? It's actually the separation of powers, that each branch has a specific role in the lawmaking process, is used to protect that liberty. Right? Again, not all of our rights are in the Bill of Rights or the 14th Amendment. The actual right to govern ourselves is the way our structure of government. We vote for representatives, we vote for senators, they vote for this, the president signs, we also vote for it. It's a structural protection of the freedom to govern ourselves. If any one branch assumes too much power, it defeats that liberty. Make sense?
Yeah, but it does seem like a positive. I mean, the way you just described it makes it. But I also feel like when people do talk about positive and negative liberty and rights, you can also sort of flip it, like oh well, freedom from, or as opposed to liberty to.
I suppose you could say the right to vote in that sense is you're actually saying something to Washington that can be viewed as positive. But I view this more as a structural right, not as a positive or negative. Because it's a structural separation of powers. That's how I view it. I think your point's well made.
Okay.
But very, very good point. Yes, sir.
Would you say that the right of self-governance is implicit in the creation of the Constitution itself?
I think explicit. I don't think it's implicit. Explicit,
implicit
right?
in the creation. It's explicitly stated. The first sentence says that we, the people, are creating this.
Right. Yeah. No, I think
We
it's
are establishing.
I think it's
this.
implicit, but I think it's more explicit. There's specific ways of how you vote, how laws are passed. I think the Constitution spells that out in great detail. I don't think you need these sort of implicit arguments. Other questions on Roberts before I go into the dissents in my remaining 10 minutes? Wish I had more time. Let's move on to Scalia. You know, in hindsight, it's Justice Scalia left us too soon, but I'm at least grateful he's around for this dissent because he was building up to this one for a long time. Because he dissented, guys, in Romer, he dissented in Lawrence, he dissented in Windsor, and I told you so in Obergefell, right? It's like, I told you guys, I told you this 20 something years ago. So at least Nino had his parting salvo. He was irate with this one, although he had a special almost like resigning of like, okay, I lost. Scalia writes, today's decree, not an opinion, not a decision, but like a decree, like what a king would issue, right? Today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. I think Scalia's opinion mostly speaks for itself. It's more or less the same points he made in Windsor and Lawrence, that this is ending the debate. The opinion lacks even a thin veneer of law. God, this one. Buried beneath the mummeries and straining to be memorable passage of the opinion is a candid assertion. No matter what it was that the people ratified, the 14th Amendment protects those rights the judiciary, in its reasoned judgment, thinks the 14th Amendment ought to protect. So it's whatever the majority thinks is worthwhile. Then he attacks the composition of the court. They're all from Harvard or Yale. 8 of them grew up on the coasts. Only 1 hails from the vast between. There's not a true Westerner. California does not count as being a Westerner. Curiously, there are no evangelicals or Protestants. There are 5 Catholics and 4 Jews, which is entirely unrepresentative of the United States. And he refers to this as a select petition panel of 9. So he was very strong. He refers to this as a judicial putsch. If you get the reference, when the Nazis came to power, it was called the Putsch Hall. So the beer hall putsch, where basically the Nazis just overcame and took over this beer hall in Germany. He calls the style egotistic, extravagance, thoughtful expression. He refers to the majority opinion, footnote 22 on page 49, as the mystical aphorisms of a fortune cookie. I mean, he held nothing back. I mean, he said that this opinion diminishes the court's reputation for clear thinking and sober analysis. And among law students who will be reading this opinion for generations, I think that may prove to be true. Hubris is sometimes defined as overweening pride, and pride we know goeth before a fall. He was really angry. He was really angry. It speaks for itself. I can't even do justice to the reading of it. I wish you would have. I was going to be a reading of. Maybe I'll play for your next class, Scalia from the bench, but I don't have time now. So, questions on the Scalia dissent. Anything jumped out of your mind? The Scalia dissent. Patrick?
So, you explained that he was very angry, but are there anything that you're stress about using the law to arrive to this right to?
I mean, he makes the point that the Constitution shouldn't be updated based on whatever judges think. Standing on 1 foot, literally, that's what it means, right? That the 14th Amendment should not be updated based on whatever the judges of five judges think ought to be the law. Right? He says this doesn't even pretend to have law. It's unfortunate that that Professor Chemerinsky, whose book you may use, has decided to exclude the Scalia dissent from his casebook. He thinks it's too hurtful and hateful. I think it's an awful decision. Whether or not the language makes people feel perhaps uncomfortable, he makes charges the majority does not reply to, and it's worthwhile to study. All right, the Thomas dissent we've discussed before about the difference between positive and negative. The right to freedom from government, not the right to government, not the right to government entitlements. That the petitioners have been deprived of no liberty, that they can live together, have relations together, have children together. All they're asking for is stuff, and the Constitution does not protect the right to stuff. And he also rejects this positive notion of dignity. Okay, a few minutes left. Okay, any questions in the Thomas? I really apologize for going so quickly. I mean, we need more credits for ConLaw. It's awful. Yeah.
Just kind of about the sense in general, because they all apply the same.
Yeah, it's pretty similar.
Same thing. They all seem to completely stomp all over substantive due process, and they, in the way that the majority apply it.
Yes.
They in Lochner itself, especially for the Chief Justice, they seem to say that it's horrible in that sense. But it seems like in other cases they've been very supportive of substantive due process. So is it just the way?
So the answer is Glucksberg, the assisted suicide case you mentioned before. That was viewed as a substantive due process that conservatives could like. You only enforce those rights that are rooted in history and tradition. That prevents judges from making up new stuff. Obergefell overturns Glucksberg. Doesn't say it, but basically overturns it. So they're not saying that substantive due process altogether is wrong. Thomas has said that. Scalia has mostly said that. Roberts and Alito haven't. But they're objecting to the manner in which it's being applied here, where it's totally untethered to history and tradition. That this is just freewheeling, make up as you go along, hopefully it sticks to the wall. So any other questions on the Thomas dissent? My remaining minute, I'll talk about Justice Alito. He talks a lot about tradition and the fact that before 2000, same-sex marriage doesn't even exist. And the idea that you can go from the Netherlands in 2000 to the Constitution mandating 2016 to him is a surreal position. And even though marriage has changed, and now it's about the happiness of people and not just, coverture and property or whatever, that this is something for the democratic process to put forward. This will cause, quote, a remedial corruption of our legal culture's conception of constitutional interpretation. So where do we leave this, right? I mean, I just spent the last 2 hours bashing the majority opinion without even talking about the substance of the law. And I wish I had more time, but I don't. How does this put on a footing the idea of gay rights, right? Whether you support it or not as a matter of principle, you no longer have a Supreme Court opinion that actually is worthwhile for that worthy cause. This is an important issue which law students like we will be fighting about for, a long time. And this is what you have to go on, dignity and whatever else. So I think there's a strong cost to writing these sorts of fluff opinions because it doesn't actually give you stuff to work with. It doesn't. And to the extent that the courts will be involved going forward, this opinion will not be particularly helpful at all. There's so many lingering issues. And Justice Kennedy doesn't like scrutiny, he doesn't like fundamental rights, doesn't particularly care about due process equal protection. For him, it's all about liberty. Any other questions? I will see you all next week. Thank you so much.